Welcome everyone to the 2020 edition of Shareholder Proposals, Trends, Strategies, and Tactics. My name is Cam Huang, and I'm here with my colleagues Gary Tygeson and Troy Keller. And we are going to be discussing with you today 2019 proxy season trends and developments, a little bit of a crystal ball into the 2020 proxy season, and then also a process for responding to a shareholder proposal, which has undergone some dramatic changes this year as the SEC has released additional guidance on proxy advisory firms as well as the no action process. And then for a bonus, we're kicking in some shareholder proposal basics materials in the appendix where we address some basic questions on laws governing shareholder proposals, who's eligible to submit one, and deadlines related to proposals. Please also refer to the table of relevant deadlines that we have included in the webinar materials. So starting with 2019 proxy season trends and developments, overall the total number of shareholder proposals submitted continued its downward trend. The all-time high was in 2015 when 943 proposals were submitted, and through July 1st of this year we saw only 678. As in prior years, many submitted proposals were not voted on because they were withdrawn following discussions with the company or excluded pursuant to the SEC's no action letter process. According to ISS, almost half of environmental and social proposals were withdrawn during the 2019 proxy season, which was consistent with 2018, and 16% of all shareholder proposals were excluded pursuant to the no action letter process. A greater percentage of no action relief was granted versus last year, so the staff granted 71% of the requests submitted during the 2019 proxy season compared to 64% during the prior season. So the percentage of no action requests granted does fluctuate from year to year depending on the trending proposals and the bases for exclusion that are cited. Increasing levels of no action relief were seen across the most commonly cited grounds for exclusion, including challenges to eligibility and procedural defects, ordinary business, and substantial implementation. There was a notable decline in no action relief on the basis of vague or misleading statements. Looking to the most commonly submitted proposals during the 2019 proxy season, we see that lobbying and political contributions proposals surpassed environmental ones. We also see that human capital management proposals, specifically addressing the gender pay gap, workplace diversity, and reports on sexual harassment policies, emerged as a popular topic. The number of governance proposals continued to decline, in large part because of a reduction in special meeting proposals, which fell off the list. Independent chair and board diversity proposals remained popular. The top 10 proponents accounted for more than half of shareholder proposals in 2019, and it's notable that the Chevedden group, which is constituted of John Chevedden, Jim McRitchie, Young, and Ken Steiner, historically corporate governance proponents, announced in late 2018 that this group would begin to make environmental and social proposals. And in fact, the group accounted for nearly a third of all proposals on political spending in 2019. What we're also seeing in terms of trends in shareholder proponents is that this year organizations such as Burnmore Cole and the National Center for Public Policy Research weighed in with proposals with conservative positions on environmental and diversity proposals. And coalitions such as the National Center for Public Policy Research and the Interfaith Center on Corporate Responsibility will frequently coordinate on the filing and co-filing of proposals by individual investors. In December, Jim McRitchie and Myra Young announced their intention to collaborate with As You Sow and the Center for Political Accountability going forward. Looking specifically at environmental and social proposals, we see that 323 were submitted in the 2019 proxy season versus 433 in 2018. In terms of proposals that were actually approved during the season, we saw at least 4 on lobbying and political contributions disclosure. So they typically requested reports on lobbying and membership in nonprofits that write and endorse model legislation. at least 2 on board oversight of opioid manufacturing and distribution, at least 2 on workplace diversity reports, and at least 1 on human rights for inmates and detainees. In contrast, only 1 environmental proposal passed in 2019 compared to 5 in 2018. The one that passed was an as-you-sow-led proposal at BP that requested that they broaden corporate reporting to describe how the strategy is consistent with the Paris Accord. It is worth mentioning, though, that this proposal was supported by BP management, and so it passed with 99% approval. Looking specifically to environmental proposals, there were 88 proposals filed during the season, and examples ranged from reports on GHG reduction targets and alignment with the 2015 Paris Agreement to maintain global temperatures below 2 degrees Celsius, a phase-out of plastic products and packaging, definitely a trending subject, a report on impact of microplastics, and the issuance of sustainability reports. In terms of no action success, as reported by Inside Climate News, nearly 2/3 of climate-related proposals filed at energy and utility companies were contested, and by early May, the SEC had granted 45% of no action requests. It's worth noting that there are vote no campaigns that are being waged when climate change proposals were excluded, as happened with the Exxon board this year. There's declining average support for environmental proposals. It averaged 25.6% of votes cast compared to 32.8% in the prior year. And as mentioned before, 1 passed compared to 5 in 2018.
So just a couple of thoughts on that, Cam. The no action success rate, as you pointed out, was high, and in fact was the highest in the last 5 years. And perhaps that's not a big surprise following last year's very important precedent in the EOG Resources No Action Letter, which paved the way for excluding a proposal with a specific target for greenhouse gas reduction, specifically the 2% threshold in the Paris Accord. Another somewhat alarming development last year was the suit filed by the New York City Pension Fund against TransDigm when TransDigm sought no action relief to exclude a greenhouse gas proposal. We haven't seen proponents go to the courts very often. TransDigm ultimately agreed in settlement discussions to include the proposal on its ballot, and it ended up receiving about 35% support.
Okay. And for sure, Gary, even though we are seeing lower levels of approval this year, I think environmental issues will continue to be at the forefront of investors' minds. In fact, a recent ISS policy benchmark survey reported 60% of investors saying that companies should be assessing and disclosing climate-related risks and taking actions to mitigate them where possible. Turning to another breed of environmental and social proposals, the human capital proposals. And so here last year, 54 proposals filed. Examples include a report on the pay gap between male and female employees and plans to close that gap, breakdown of employees by race and gender across job categories, and disclosure of policies and programs for increasing diversity in the workplace, no mandatory arbitration clauses for discrimination or harassment claims. Overall, we saw lower withdrawal rates than with the environmental proposals, and a higher percentage of these proposals were voted on versus negotiated, in part because of an increase in proposals requesting additional disclosure from companies that had already been providing some relevant disclosure. And so, for example, Arjuna Capital requested that 12 major banks and technology firms report unadjusted global median gender pay gap and U.S. racial pay gap figures, irrespective of job function, level, or geography. And so these types of follow-on proposals we're seeing will get more significant pushback from companies. Overall, stable average support, 30% of votes cast compared to 28.2% in 2018, and 2 workplace diversity proposals passed compared to none in 2018. Human rights proposals reflected the top-line issues of the day, with 10 proposals receiving over 30% support compared to 1 in 2018. And if you were to look at the topics that were covered, you really just need to look at the front page of your newspaper. We're talking about proposals on the treatment of people held at correctional facilities and migrant detention centers, the establishment of an international policy committee to oversee human rights in China, reports on protecting children from sexual abuse online, and also adoption of policies that address gun violence. Turning to governance proposals, there were slightly more governance proposals filed than environmental and social proposals in 2019, which is consistent with 2018. And historically, more governance proposals are approved than environmental and social proposals because they are often filed at companies with outlying governance practices or recent controversies. More recent types of proposals include board diversity policies, and you see here that at least 2 of them were approved in the 2019 proxy season. Other types of proposals that were approved include abolishing supermajority voting requirements, lowering thresholds for shareholders to call special meetings, majority vote on uncontested director elections, declassifying boards, shareholder action by written consent, and adoption of proxy access. The number of governance proposals passed in 2019 was comparable to 2018, with the exception of an increase in supermajority voting thresholds. Those proposals passed at a higher level than the last year. So here again is a summary of the proposals where we saw increases in the number of proposals submitted as well as declines. So increases in independent chair proposals, board diversity and qualifications, and the abolition of supermajority voting threshold. It's interesting to note that the latest ISS policy benchmark survey found that investors cited poor company responsiveness to shareholder concerns as the most commonly chosen factor that strongly suggested the need for an independent board chair. This was followed by governance practices that weaken or reduce board accountability to shareholders. There were declines in special meeting proposals as well as proxy access proposals. Compared to environmental and social proposals, governance proposals are more often excluded than negotiated when they do not come to a vote. And in fact, governance proposals are a common type of proposal that is excluded on the basis of substantial implementation. We reviewed all no-action requests from October 1st, 2018 to the present, and 28 out of 40, or 70% of the proposals excluded on that basis were governance proposals. Looking specifically at a type of governance proposal, board diversity and qualification, examples included adoption of a board diversity policy or disclosure in a matrix form of the minimum qualifications for a director candidate. Higher negotiated withdrawal rates were driven by widespread investor and legislative attention to this issue. As of mid-2019, all S&P 500 companies have at least one female director. However, investors are now targeting smaller companies. Furthermore, large institutional investors such as Vanguard and BlackRock have established board diversity expectations. And starting in 2020, ISS will generally vote against the chair of the nominating committee at companies when there are no women on the board, with some mitigating factors taken into account. And that's just on the investor front. A lot of us are well aware that there's also been significant legislative movement on board diversity. California passed a law last year that requires public companies with principal executive officers located there, no matter where they're incorporated, to include a representative number of women on their boards. Illinois has pending legislation requiring disclosure of board and management diversity by 2021, and similar legislation is being considered in other states, but may be subject to constitutional challenge. It's worth noting that these types of proposals are coming from all ranges of the political spectrum. There were 7 proposals submitted by the Free Enterprise Project, which sought to shift the definition of diversity away from race and gender and towards skills, experience, and ideological perspectives. Support averaged 8% of votes cast, which was a decline from 16% of votes cast in 2018, but this was skewed by the low levels of support for the Free Enterprise Project proposals. And finally, as previously noted, 2 proposals passed compared to none in 2018. So we've covered environmental and social and governance proposals, and finally we'll be looking at a third category, executive compensation proposals. So there were a lower level of proposals submitted in 2019, 52 versus 65, even though at least 2 of these proposals on clawbacks were approved. And the examples of proposals that we are seeing are many proposals asking for an alignment of executive incentives with environmental and social issues such as sustainability metrics, drug pricing strategies, sexual harassment prevention policies, and human rights. In addition to the clawback proposals, there have also been proposals to have shareholder approval of severance and termination packages. It's worth noting that many executive compensation proposals had no action request denied this year, and they very commonly were requesting no action based on an ordinary business exemption. Now I'm going to turn it over to Gary to talk a little bit about 2020 and what we expect to see there.
Thanks, Cam. So it's time to do a little crystal ball gazing and talk about what we see for the upcoming proxy season. It's always hard to predict exactly what's going to happen, and that's even more true this year since the SEC has thrown us some recent curveballs that we'll talk about in a minute. But we've been pretty successful in the past in terms of gauging the trends year over year. So who do we think will be the leading targets in 2020? Well, anyone is fair game, but S&P 500 companies will remain the most likely targets. Certain industries will be more vulnerable, such as big tech companies, fossil fuel companies, and participants in the plastics, opioid, and firearms distribution chains. When it comes to these chains, expect proponents to cast a wide net that includes everyone from producers of raw materials to manufacturers to distributors and retailers. Even financial institutions may be caught in this net. A recent proposal submitted to Visa requests a report from the Board on Risks to Visa from the mounting public scrutiny on the role of credit card issuers and other payment intermediaries in enabling purchases of firearms, ammunition, and accessories. In addition, companies with governance provisions that are outside the mainstream or their peer group will also be targets. Who do we think will be the leading proponents in 2020? Well, we expect to see a lot of the same players, Cam. The Chevedden Group, the New York City Comptroller's Office, and investor coalitions that submit through individual members like the National Center for Public Policy Research and the Interfaith Center on Corporate Responsibility are all going to be leading proponents. We also expect to see the continued emergence of employee activist groups in 2020, like Google and Amazon experienced in 2019, as well as special interest coalitions. There's simply a lot of activism out there. For example, a coalition of 99 investors plans to send letters to 3,000 global companies calling for more transparency on human capital issues, and it will be interesting to see if those letters morph into shareholder proposals. Our big picture view of the major categories of topics for 2020 leads off with environmental and social issues. We think that will continue to be the largest category of proposals in the coming year. This continues the trend in recent years where environmental and social matters have become much more mainstream issues, not just limited to activists who want a clean planet and social justice, but tied to the long-term economic health and viability of the enterprise. We expect to see a continued rise in proposals relating to human capital and political issues, and a continued decline in governance and compensation-related proposals. And we expect that the number of anti-ESG proposals will remain relatively small, driven by such advocates as the Burn More Coal and Free Enterprise Project. Now let's drill down into each of the major categories. For environmental proposals, we expect to see fewer proposals on topics related to climate change, especially those with specific targets that can be excluded as ordinary business and micromanagement. We expect to see more proposals on other environmental issues, including such topics as recycling, renewable energy, plastics, and sustainability reporting. Net, we look for continued decline in the overall number of proposals in this area and continued support from shareholders. Political proposals, the largest single category in 2019, will remain strong in 2020 due to traction in 2019 and the run-up to the election year in 2020. Proposals we think will be focused on the disclosure of political contributions and lobbying. Human capital proposals will continue to rise and cover a wide range of issues. Everything from gender pay equity, workplace diversity, and diversity of executive management, to sexual harassment, more expansive disclosure, and a wide variety of human rights issues. It's possible this trend might be offset as more companies expand their disclosures of human capital management. Governance proposals will continue to decline as companies remain proactive in adopting governance best practices. We expect proposals will focus on provisions that are out of the mainstream, such as classified boards, plurality voting for directors, supermajority vote thresholds, a 20% or greater threshold to call a special meeting, and dual-class shares. We also expect to continue to see proposals on governance topics where the market practice has not yet settled, such as the perennial issue of the independent board chair. Proxy access proposals, which exploded onto the scene several years ago, will continue to decline. We expect the proposals to adopt proxy access bylaws will be down again in 2020, as over 70% of the S&P 500 have already adopted proxy access bylaws. And quite frankly, we really haven't seen a push downstream to smaller companies. Where these proposals are put forward, they're likely to be resolved through negotiation or passed. Proposal to amend proxy bylaws, so-called proxy access fix-it proposals, will also decline. Most bylaws already follow the market standard of 3.3.2020, and these proposals have gotten very little traction. Where proposed, they're likely to get ISS support, but fail to pass. Compensation-related proposals will continue to be few in number, continuing the trend we've seen following implementation of say-on-pay. The focus of these proposals we think will be tied to compensation targets for social and environmental performance goals. Trillium has announced an initiative linking diversity metrics to senior executive comp, and we expect to see proposals linking exec comp to other metrics such as cybersecurity and data privacy. We think there will also be a focus on workforce equal pay as part of the surge in human capital proposals, and we can expect to see clawback proposals, especially for companies that have experienced significant lapses in oversight. So how will proposals get resolved in the coming proxy season? We think about half will go to a vote with a small percentage winning majority support. Many proposals will be withdrawn following negotiations, as investors and companies tend to be more willing to reach a compromise in some areas. Some proposals will be excluded, based primarily on substantial implementation in ordinary business. In rare cases, efforts to exclude may lead to suits, as we saw in TransDigm this past year, or a vote against campaign, as we saw in Exxon. Shareholders will also continue to use exempt solicitation filings to publicize shareholder proposals that are up for a vote. When it comes to negotiated withdrawals, Cam, not all proposals can be lumped together. This table, based on ISS's June report, shows that environmental and social proposals are far more likely to be withdrawn after discussion with companies than governance proposals, as they allow more space for negotiation and a win-win outcome, and as companies are increasingly aware of the importance of putting the right face on their environmental and social initiatives. How do we think the SEC will respond to no action requests? Well, we've got some breaking news here, not as riveting as the impeachment hearings that you might have going on simultaneously, but definitely a potential game changer in the world of shareholder proposals. Just this month, the Division of Corporation Finance announced that the staff may respond orally instead of in writing to some shareholder proposal no action requests. the staff still intends to issue a response letter where it believes doing so would provide value. This obviously raises a lot of questions. How will oral responses be made available publicly, if at all? How broadly will oral responses be given, and how will they be made so that we can all take advantage of knowing the precedents? Furthermore, the announcement said that the staff may now more frequently decline to state a view on the no-action request. If the SEC declines to take a view on a no-action request, the company is faced with a decision to negotiate, take a vote on, or exclude the proposal, with the potential for litigation. So this also raises a lot of questions about what the company and proponents should do in this situation, which up until now has been very rare. So far, both companies and investors seem to be unhappy with this announcement, particularly with the uncertainty being introduced into a process that was previously fairly well defined, although somewhat controversial. 5 large and powerful investor organizations, including the Council on Institutional Investors, wrote a joint letter to the SEC expressing concerns with the revised no-action process, predicting reduced transparency and decreased accountability. They actually requested the staff rescind this change in process. Short of that, they urged the staff to only decline to take a view in exceptional circumstances, to establish clear criteria, to establish early time frames, and to clarify online posting and specify procedural safeguards for oral decisions. So Cam and Troy, I'd really just like to pause here a moment and get your thoughts on this recent development and what you think it means for the upcoming proxy season.
Well, clearly, Gary, I think the SEC is going away from helicopter parenting to free-range parenting here when it comes to stepping into the conflicts between investors and the companies where they're submitting proposals. Assuming that this guidance stands and that there is a little bit more uncertainty as to whether or not the SEC is going to express a view, I find it unlikely that companies will be unilaterally excluding proposals without SEC concurrence on a common basis. They'll just be leaving themselves open to proxy advisory firm recommendations against their directors, negative investor attention, and potentially litigation. I would suspect that we will see more negotiated withdrawals as a result of this shift in SEC position. And we'll also need to see a little bit more preparation so that companies should have a representative that is prepared to receive the SEC's call and ask appropriate questions and obtain as much clarity as they can. And furthermore, companies will have to give some thought as to creating a proper record so that they can properly treat the shareholder proposal that's in front of them as well as future shareholder proposals, and also report back to the board and the company's decision makers on the conversation.
I think that's all exactly right. I mean, you've covered the bases pretty well. I think companies, it'll be incumbent on them to do a little more digging, and there is more information. For example, there used to be on the website of Proponents. You can find more information on what Proponents are trying to do, where they're headed. I think that's a good source of information. And then, and I think the SEC is certainly not done. We see things coming out, it seems every month at least, if not weekly. Earlier this week, there were hearings in the House Financial Services Committee, and with Chairman Clayton and other commissioners, and there the SEC made it clear they were still looking at additional improvements and adjustments in the proxy advisory process and shareholder proponent process as well. So I think there's still more to come, and we'll have to keep our eyes and ears open.
Yeah, for sure. And in the meantime, check out our recommendations in the attached e-update. It's in the materials.
Another area for potential change in the 2020 proxy season will be the role of proxy advisory firms like ISS and Glass Lewis. As you may recall, ahead of last year's proxy season, the SEC staff withdrew 2 no-action letters that had provided a great deal of comfort to investment advisors who wanted to rely on proxy advisory firm recommendations. The withdrawal of these no action letters last year created some uncertainty around the circumstances in which investors could rely on proxy advisory firm recommendations and when a firm might be considered independent. Then, just last month, the SEC made its position quite clear in two related releases issued on August 21, kind of stepping into the vacuum that was created when they withdrew their prior no action letters. The SEC first provided commission-level guidance to investment advisors, reminding them that they are fiduciaries and admonishing them to take certain actions in order to fulfill these duties if they're going to rely on a proxy advisory firm when voting their customers' shares. Second, the SEC made it clear that voting recommendations provided by proxy advisory firms are solicitations subject to the federal proxy rules, including the anti-fraud provisions. So this definitely ups the ante in terms of the recommendations being put out by proxy advisory firms. This double-barreled response tried to address concerns that we've been hearing for some time, as we've seen proxy advisory firms exercise a significant amount of influence over shareholder votes, but they are completely unregulated. In addition, they can have conflicting interests, which have raised a lot of concerns. And sometimes their recommendations contain factual or analytical inaccuracies that are difficult, if not impossible, to correct prior to the annual meeting. The bottom line is that investment advisors and proxy advisory firms are going to need to review their policies and practices and may need to make some substantial adjustments going into this year's proxy season. For key takeaways from this August 2019 guidance, you can take a look at our e-update provided with your materials. But in short, we can expect to see increased transparency and accountability for proxy advisory firms and the investment advisors that rely on them. Among other things, this will lead to increased due diligence by investment advisors of the proxy advisory firms. We can also expect to see disclosure of conflicts of interest by proxy advisory firms, which I'm personally looking forward to reading. Proxy advisors will need to take extra care in backing up the accuracy of the information and methods they use, and there may actually be some leverage here for issuers to challenge voting recommendations and perhaps some more time and a better process to resolve errors in those recommendations. Some small investment advisors may get out of the business of voting so that they don't have this fiduciary responsibility. On the other hand, larger institutional investors already have implemented their own proxy voting guidelines and processes and generally don't rely on ISS and other proxy advisory firms. The bottom line here, Cam, is I think we're going to expect to see more process, more transparency, and more accountability, but at the end of the day, there probably won't be a big impact on the actual voting policies or specific voting recommendations coming out of proxy advisory firms, or for that matter, on the number of investment advisors that follow those policies or recommendations.
Well, for sure, many large institutional investors already have very sophisticated proxy voting departments in-house.
Finally, there's some other changes under consideration, the legal requirements that could impact shareholder proposals in 2020, but it's unlikely that they will be adopted prior to the proxy season. We're looking for some possible further actions by the SEC, including rulemaking on proxy advisory firms instead of the guidance that was just issued. Minimum thresholds for shareholders to submit and resubmit proposals has been in the works for a while, and we expect that to be forthcoming. And also proxy plumbing reforms covering a wide variety of topics. There's also pending legislation in both houses of Congress, but that seems to be stalled at the moment.
Yeah, and I'd just add there, Gary, that the pending legislation is not limited just to this topic. There have been a flurry of corporate governance proposals over the last year or so, and some of them very political, some of them not so much. These, I think, people don't expect these proposals relating to, or this proposed legislation relating to the proxy advisory firms to really go anywhere. However, they did send a message. One of them, for example, the one at the Senate level, the Corporate Governance Fairness Act, was introduced in the Senate the same week literally the day before the proxy roundtable that the SEC held last year. So, no coincidence there, and you can see, you can see people on both sides, both in the executive and the legislative branch, sort of coming out and symbolically showing what they'd like to see happen. Moving to process for responding to proposals. We're going to discuss a few steps here, some best practices, and just some considerations to have in mind for dealing with the proposal when it comes in. And in fact, in some ways, the first strategy, and maybe the best one, is to know what you're going to do and what the company's positions are going to be before the proposals even come in. And that's both in terms of being strategic about what your priorities are in the company. We've listed out a few bullets here that might be worth thinking through and considering as a management team, and determining where the company might, what its goals might be in advance of a proposal coming in. For example, is your priority to have a strong relationship and reputation with shareholders? That's obviously always a priority, but sometimes you've got to balance different priorities. Collaborating with shareholders to further study the proposal could be a goal or an approach. Is it your priority to discourage future proposals? Or is it a priority, for example, to minimize disruption to the board management process, taking more of a hands-off approach, for example? I'll just reiterate on this that, again, this kind of all starts before a proposal comes in. It's been true for a while now that year-long engagement with major shareholders, and really all shareholders, is key to being prepared for shareholder activism of all kinds. And so I think it's important for companies to again, think through what the priorities are before the proposal comes in. When it does, there are a few other things to keep in mind. And first off, I would say once you've got the proposal in hand, make sure that the deadlines you have to work with are clear and top of mind for everyone. Frequently, management will, and even the board level, will get involved frequently in determining how to address a proposal. So just make sure you know what those deadlines are, and we've included a timeline in the back that could be pretty useful there. Next, a lot of proposals since October 1, 2018, in fact, over 50% of no action requests that were based on eligibility and procedural compliance were granted by the staff. So make sure you look closely at those aspects of the proposal when it comes in. So, for example, was it submitted in compliance with the ownership and the timeliness requirements? And we set those out again in the appendix here. Did it exceed the 500-word limit? Is it the shareholders try to do more than one proposal for a particular meeting? Those are the kind of things to scrub when the proposal comes in. And if you are going to take action in that respect, there are some timeline requirements to notify the proponent, and then you can seek exclusion. Moving on to another thing to be aware of here in this early stage, you're looking at the proposal when it comes in, and that is that it is allowable for proponents to do so through a representative, and that's consistent with the proxy rules. However, they do need to satisfy some technicalities. So, for example, or some formalities, rather, I would say. In that respect, the staff would look for actual documentation that shows that the proponent and the person or entity have been selected as the proxy, that the company is properly identified, the proposal is directed to, the specific meeting is clear there, and the specific proposal, and it's signed and dated by the shareholder. So again, this can be a basis for exclusion, but it's good to note that it's not really as much of a foot fault approach as perhaps some of the other procedural requirements for proposals can be. The staff allows a measure of flexibility there, and just looks to see that a reasonable conclusion of eligibility has been done there. Okay, so let's say that your strategy is to go ahead and include the shareholder's proposal into your proxy statement. Again, be cognizant of the time frames here. You've got, the company must send the proponent a copy of its opposition statement no later than 30 days before it files its definitive proxy statement. And the proponent then has the opportunity to challenge what it views as any false or misleading statements. The proxy statement itself must include the shareholder's name and address. Again, some technicalities, but important to remember. It has the option, though, to instead include a statement that will provide the information to shareholders upon request. And then finally, and this happens more often than you would think, if the proponent or the qualified representative fails to appear and doesn't present good cause and fails to appear and present the proposal, because as I think as many of us are aware, they have to be there at the meeting and verbally stand up and present the proposal. If they don't appear, the company is permitted to exclude all of that proponent's proposals for the following 2 calendar years. Then one last trap for the unwary here, or really just item to be really prepared for when you are including a shareholder proposal, is a trend that we've seen over the last couple of years really pick up steam here, where proponents are under Rule 14A6G1 are using exempt solicitation filings to broadcast their response to a company's opposition statements. And when that happens, again, the company has an opportunity to decide what it's going to do, whether to respond or not respond. And if the company does, they just need, again, to be very careful to follow the securities laws that regulate how those responses can be made and in what in what context. So, for example, the SEC has taken the position that even websites, email correspondence, and scripts used for oral solicitations can be considered proxy soliciting materials that would need to be filed. It's important to post the materials on the same website as the original proxy materials and no later than the date of the supplemental materials first sent or made public. So again, it's important to decide what steps the company will take in that regard. So that covers some of the topics we wanted to discuss when a proposal has come in and you've decided to include it. If you've decided to do the exclusion process, that's where the real fun begins. And Cam, over to you on that.
Yeah, thanks, Troy. And just before we get to that, just back on the exempt solicitations, one note I'd say is it is a matter of judgment whether or not you end up mailing any supplemental materials to shareholders. Often people think, well, we have to mail it, right? But actually you don't. I mean, you have to file it. You don't necessarily have to mail it. But it is a matter of judgment. It really kind of depends on how material the information is. I mean, it's obviously the more cautious decision in any circumstance. So we've gone through some mechanics on including shareholder proposals. Let's go through some of the mechanics on excluding a proposal. So the company would submit a request for a no-action letter to the staff of the Division of Corporation Finance, and more than one basis for exclusion may be and often actually is cited. There's a no-action letter from the staff, which would provide its informal view regarding whether it would recommend enforcement action to the SEC if the company takes the course of action described in the no-action letter request. A company must send the SEC a no-action letter request at least 80 days before the date it plans to mail its proxy statement to shareholders and simultaneously provide a copy to the proponent. And then after that, the proponent may submit its own statement to the SEC. The staff considers all arguments and issues a decision typically within 30 to 60 days of receipt, even though it'll be interesting to see whether these timelines get compressed or shortened as the SEC is striving towards a more efficient process. And stepping back, what you're seeing is that there are a number of decision points when a company receives a shareholder proposal. So there's the analysis of the eligibility, there's a decision about whether or not to include or exclude it. And so we really recommend that you put together kind of a decision tree that will walk through the various points and kind of keeps everyone on the same page and helps you to strategize about the shareholder proposal. And so we've included a decision tree in each of our annual presentations. I'd like to highlight a few of the changes that have occurred this year because of the new SEC guidance. And so one change to this year's decision tree is, number one, if the SEC declines to take a view on a no action request, then the company is faced with the decision to either negotiate the proposal, potentially to withdraw it, or to take a vote on it, or to exclude it without SEC concurrence and with the potential for litigation. So that's one new development in the decision tree. A second development is that companies should be prepared to respond to a vote no campaign if a proposal is excluded. We've seen this in a number of instances over the 2019 proxy season, and we would expect to see the same in future proxy seasons. And a third development, companies should consider a response if a proponent files an exempt solicitation after the proxy filing. So those are highlighted here, and just a resource for you to consider as you're taking a look at your very specific shareholder proposals. Beyond shareholder eligibility, there are 13 substantive bases for exclusion under Rule 14a8, and what we've done here is we've summarized the number of no action requests granted under each basis from October 1st, 2018 to the present. And then we've also listed the approximate number of times that this basis was cited, whether as a primary or a secondary basis, and we kind of, calculated our own success rate based on when it was granted and then how many times it was cited. And so it actually covers 2 pages here. It's a little difficult to flip back and forth, but the top line for a lot of people is that substantial implementation and ordinary business had the largest success rates out of the commonly cited bases for exclusion in 2019, and also resulted in a significant number of withdrawals. While alleging materially false or misleading misstatements under 14a8I3 was not successful at all, it was cited 42 times in the last year, and there was only one request that was granted on that primary basis. So that's actually very notable. Keep in mind that companies typically will not pursue no action requests unless they have confidence that they can prevail, so the success rates do tend to be higher. And so there's been a lot of discussion about the role of board analysis and how that can bolster exclusion requests based on ordinary business or economic relevance. Troy, I was wondering, did you run across any proposals that successfully used board analysis in an economic relevance exemption this year?
There was one, and so it's a basis that shouldn't be completely ignored. And Reliance Steel and Aluminum received. We had success in here. The proposal was one that related to a report on political contributions and expenditures, which in those proposals did have some success this year. But in this case, the company was able to exclude it. Using this basis, they were able to successfully demonstrate that the parts of their business that it related to was less than 5% of total assets, net earnings, and gross sales, which is one leg of the test. And so yeah, Cam, there was some success, and again, we should keep this one in mind.
Yeah, for sure. It's very circumstance specific. I think in this situation, the company was clearly able to demonstrate that the issue had an impact of less than 5% of total assets, net earnings, and gross sales. The inclusion of board analysis is very nuanced analysis, and that's something that Gary is going to go more in depth on as we talk specifically about a couple of bases for exclusion, namely ordinary business and substantial implementation, since they were frequently relied upon in the 2019 proxy season.
Yeah, so we want to camp out on the ordinary business exclusion for a few minutes because, as Cam said, it was the most commonly cited basis for exclusion in the 2019 no action requests and the second most successful basis for exclusion, right behind substantial implementation. In addition, it's a pretty complex and involves a number of overlapping layers. The rule permits exclusion of a proposal that deals with a matter relating to the company's ordinary business operations. Two basic considerations for evaluating whether an activity is excludable were articulated by the SEC in its 1998 release. 1, the tasks are fundamental to management's ability to run a company on a day-to-day basis. Or 2, the proposals seek to micromanage the company by probing too deeply into matters of a complex nature. The bottom line here is that these matters are really best left to management oversight rather than to a shareholder vote at an annual meeting. However, the exclusion is not available for policy issues that are so significant as to transcend ordinary business matters. What constitutes a significant policy issue continues to be very subjective and a matter of debate. As I mentioned, there are multiple layers to this exclusion, and we're going to focus on the third level for a moment. Is there a significant connection between the significant policy issue and the company's business? And to what extent is board analysis required or helpful in getting no action? This has been the source of a lot of confusion in recent years, as we've all tried to discern where the SEC's staff is going on this one. So where is the staff guidance clear and where is it murky? First of all, not all requests under the ordinary business exclusion must include board analysis. For example, circumstances where companies have historically been permitted to exclude the proposal may not require board analysis. There is no expectation of a new full board analysis where there is already a well-worn path to exclusion under the circumstances. So do your no action letter review research and see what you find. But you're going to find, among other things, management of the workforce, such as hiring, promotion, and termination of employees, decisions that relate to production quality and quantity, and proposals that relate to the retention of suppliers to the company. Ordinary business exclusions granted without board analysis last year included a proposal requesting company offer shareholder discounts on products and services that are available to employees. This seems to make sense, but it was disappointing to me on a personal level as I was thinking about the benefits of being a shareholder of Best Buy or Target or Amazon, if this caught on. There was a proposal requesting face-to-face annual meetings to replace current remote or virtual meetings. This was a little surprising to me since it deals with a primary interface between the company and its shareholders, but nonetheless, the staff granted no action, probably looking at the annual meeting as a detailed function of running the business. A proposal requesting board commission an independent study of amendments to the company's governance documents to enhance the board's fiduciary oversight of matters relating to customer service and satisfaction, and a proposal requesting the board to prepare a report to evaluate the risks of discrimination relating to policies and practices for hourly workers who take absence from work for personal or family illnesses. Notwithstanding these exclusions, we would caution you that the analysis is very fact-specific. In a number of no-action letters, the SEC staff specifically noted the absence of a board analysis. So when is the board analysis required or desirable under the ordinary business exception, and what should that analysis look like? Obviously, I think it goes without saying that board analysis is a big step in the no-action letter process and decision tree, as this is going to require some significant additional care and time to get board input. For this, you need to take a look at the SEC's guidance from Staff Legal Bulletin 14I, Staff Legal Bulletin 14J, and the no-action letters. If the ordinary business matter is not self-evident, a discussion of the board's analysis of the significance of the issue to the company will likely be necessary. The request should discuss the specific proposal and its application to the company's specific operations. Details can include board meetings and discussions with consultants, although board materials are not required to be included. The request should also discuss in detail any specific differences between the action requested by the proposal and the company's current policies, practices, procedures, and disclosures. Prior shareholder engagement on the topic is worth pointing out, as well as whether there has been a recent shareholder vote on a similar proposal, and if so, citing the most recent vote and the actions taken by the company following the vote. So how did the staff come out on requests last year under the ordinary business exclusion that included a board analysis? Bank of America was allowed to exclude a proposal requesting that the board prepare a report to shareholders that evaluates overdraft policies and practices and the related impact on customers. Yum! Brands was allowed to exclude a proposal that the board adopt a policy prohibiting the company from engaging in certain employment practices, in particular mandatory arbitration of employment-related claims, non-compete agreements, and non-disclosure agreements arising in connection with a settlement of claims relating to discrimination or harassment. However, PNM was not allowed to exclude a proposal requesting that the board prepare a report to shareholders on the company's efforts to identify and reduce environmental and health hazards relating to the handling of coal ash and related reduction of legal, reputational, and financial risks. Notwithstanding 3 pages of board analysis that went slavishly through each of the 6 factors outlined in Slab 14J, the staff simply was not convinced and found that this proposal transcended ordinary business matters. Obviously, I think the nature of this question and the policy relating to environmental matters ruled the day. Finally, I just want to touch briefly on the last layer of the ordinary business exclusion, micromanagement, which was a very successful path for exclusion last year, totaling approximately 21 successes. As you might imagine, micromanagement is typically granted if the proposal involves intricate details, seeks to impose a specific time frame or method for implementing complex policies, or seeks to impose a specific outcome on the company. Examples from last year's proxy season where the staff granted no action included proposals that imposed specific targets on greenhouse gas emissions, required specific website statements, required shareholder approval of all stock repurchases, and prohibited specific compensation practices. The other most successful basis for exclusion in 2019 was a substantial implementation basis. Troy, what can you tell us about what happened last year in substantial implementation?
Yeah, so thanks, Gary. So the original rule was designed to avoid the possibility of shareholders having to consider matters which have already been favorably acted upon by management. And interestingly enough, it didn't actually include a concept of substantial implementation, but the SEC took mercy on companies and later adopted that standard in 1983 and then subsequently in 1998. For sure, it continues to be one of the most used and successful bases for exclusion. In fact, it accounted for 39% of all exclusions granted in 2019 and had a 49% success rate. So that's a winner. 70% of these successful requests related to governance proposals. And in granting requests, the staff frequently concludes that the company's policies, practices, procedures, or public disclosures, quote, compared favorably, unquote, to the proposal, or alternatively, the company's board will provide shareholders with an opportunity to approve the proposed changes at the next annual meeting, approve the necessary amendments for submission to a shareholder vote, or the company intends to present those amendments for a shareholder vote at the next annual meeting. Just a practice tip, if you're planning to invoke this exemption, definitely include a copy of the company's policies or relevant disclosures that compare favorably to the proposal. Otherwise, the staff may only grant the request upon reconsideration once the policy is included. And so, actually, we're running up on time here. This concludes our presentation on shareholder proposals for the 2020 proxy season. Please email any of us if you have any questions or comments, and consider attending our December presentation on preparing for the 2020 proxy season and annual reporting, which will cover a broader range of topics beyond shareholder proposals. Thank you very much for your time.